On a Tuesday morning in September of 1987, Harlan Dempsey was pulling a loaded gravity wagon through the East Field when his left arm simply stopped working. There wasn't any real pain to speak of, but it felt as if the arm had decided it was finished and didn't bother to ask the rest of him for permission. He let go of the steering wheel while the Oliver 1800 kept rolling through the standing corn, slow and steady, pulling that wagon toward nowhere in particular. Harlan went down between the rows, and the machine just kept on going without him. The tractor was still idling when they finally found him 20 minutes later, give or take. It was just the sound of the engine, the rustle of the corn, and the wide September sky. He had spent a lifetime building something worth stealing. Now, his own sons were about to prove it. Let me tell you about the man, because you need to understand him before you can understand what he did. Harlan Dempsey was 67 years old and had farmed the same 320 acres in Clayton County for 4 decades. He didn't start with much back in 1947, when his father-in-law shook his hand and told him the land was his to earn, but not his to own just yet. Harlan took that distinction to heart and paid the debt down slow through the dry years and the wet ones, through the war in Korea and the commodity crashes that followed. When the deed finally cleared in 1963, he drove to the courthouse himself to pick it up, then kept it in a fireproof box under his bed. He didn't use a dresser or a filing cabinet because he wanted that paper where he could reach it in the dark. The farm crisis hit Clayton County, just like it hit the rest of Iowa, which is to say, it hit hard and offered no apologies. Between 1981 and 1986, land values dropped 60%, and Harlan watched the federal land bank foreclose on the Kettner place only 2 miles east. That was good ground and a good family. But they were gone because the debt load got out ahead of the acreage. Harlan swore he wouldn't borrow against his dirt, not even once. And while his neighbors thought he was being stubborn, he just thought he was paying attention. He had 2 sons, and Dale was the older one, at 42 years old in 1987. Dale had always believed that knowing what needed to be done was the same thing as having the right to do it. Roy was 38, the younger brother, and he had spent most of his life standing 2 steps behind Dale while signing whatever was handed to him. It wasn't that Roy was a weak man, but more like he had never been given a single reason to think for himself. The boys worked the farm because Harlan let them, but there was one piece of equipment he never handed over without being asked, and that was the Oliver 1800. He bought that tractor used in 1969 from a dealer outside of Monona, paid the full price in cash, and made sure the title was in his own name. He kept the machine running himself, handling the hydraulic seals, the distributor points, and a fuel line that always needed a little persuading on cold mornings. 24 years of repairs were logged in a spiral notebook he kept in the toolbox bolted to the left fender, with every fix dated and every part noted. That tractor wasn't a shared asset, but belonged to him the same way the deed and the decision-making belonged to him. Some men hold on to their legacy with anger, but Harlan held on with patience for 40 long years. He built all of this slowly, which is the only way you build anything meant to last. It was one payment at a time, one season at a time, and one careful decision at a time. But while he lay unconscious in the Clayton County Hospital, his sons were moving fast, and on a farm that took 40 years to build, fast is almost always the wrong speed. Dale got the call around noon. Harlan was alive, but his left side was weak, and his speech was coming out slow and scrambled. The doctors said he would likely pull through, but they couldn't say how much function would come back or how fast it would happen. Dale drove to the hospital and stood at the foot of the bed for a few minutes before driving home. By the next morning, he was standing in the county courthouse. Now, let me pause here and ask you something, because you need to understand the pressure Dale was feeling for this story to make sense. There was a $47,000 operating loan sitting with First Savings Bank in Elkader that was due in November. Dale and Roy had co-signed that note. With corn prices where they were and land values still sitting in the ditch from 5 years of crisis, Dale had convinced himself the bank was going to move on the farm no matter what. He had watched it happen to too many neighbors not to believe it could happen here. And to him, the fear and the math were both very real. What he did with that fear is where the trouble starts. At the courthouse, Dale found a power of attorney document that Harlan had signed back in 1981. It was a narrow instrument drawn up for a specific purpose, which was a grain bin construction deal that had been built, paid for, and settled years before. The POA had no expiration date written on its face, and that was the only part Dale chose to focus on. He didn't worry about what the document was actually meant to authorize, or whether a transaction completed 6 years earlier had ended its purpose. He took that paper to First Savings Bank and handed it to the loan officer. The loan officer accepted it without much fuss. Maybe he didn't read the fine print carefully, or maybe he was under his own pressure while sitting on a portfolio full of distressed farm loans. He was likely eager to restructure anything he could before that November due date. Either way, he stamped the papers and moved the process forward. Within 4 days, the whole thing was finished. Dale and Roy mortgaged 200 of the 320 acres for $68,000 and used that money to retire the operating loan. That move took $47,000 off the table and left roughly $21,000 to be split between the two brothers. The remaining 120 acres were divided with a quitclaim deed, where Dale took 80 and Roy took 40. It only took 2 signatures and 1 notary, and they never made a single phone call to Harlan. Harlan was still lying in the hospital when the ink dried on those deeds. His speech was still slurred, and his left hand couldn't grip a bed rail. He didn't know what had happened because nobody told him, and the only people who could have told him were the ones who had done it. Now, let me tell you about the law, because there is a difference between breaking it and bending it past recognition. A man who breaks the law usually knows what he is doing is wrong. A man who bends it has usually talked himself into believing he is doing the right thing. Dale wasn't hiding in the shadows, as he used a real courthouse, a real bank, and a real notary to get his way. He told himself he was saving the farm from foreclosure and doing what a son does when his father can't lead. He told Roy the same thing, and Roy, who had never been given a reason to push back, just went along with the plan. The truth was that the POA had expired when its purpose was met. No conservatorship had been filed with the court, and no judge had ever declared Harlan Dempsey incompetent to handle his own affairs. Without those legal steps, Dale had no authority to touch that land. Not one single acre of it belonged to him. Harlan couldn't talk right yet, but he could still listen. The first thing he heard clearly was his daughter-in-law out in the hallway telling a nurse that the farm situation was handled. He stared at the ceiling for a long time after he heard those words. He couldn't grip a pen at first. His left hand was useless against the hospital blanket, and his right hand shook so badly that writing looked more like a series of jagged gestures. But he could still point. He got the nurse's attention and pointed at the notepad on the tray table and the pen sitting beside it. When she put the pen in his right hand, he bore down with everything he had and wrote one word in letters 2 inches tall. Deed. Meredith understood exactly what he meant. She drove home that afternoon and went straight to the bedroom to pull the fireproof box out from under the bed. The original deed was gone. In its place sat a photocopy, just plain paper run through a machine, along with a handwritten note from Dale that told them not to worry because the boys had handled it. She brought that box back to the hospital, along with something else she had found. It was a quitclaim document she discovered folded in the glove box of Dale's truck when she borrowed it to haul some feed. She didn't know the legal specifics of what it meant, but she saw Harlan's name on it without Harlan's signature, and she knew that wasn't right. Harlan's right hand was still shaking, but he read every line of that document twice. The left side of his face was still slack from the stroke, yet his eyes moved with the same quiet attention he had brought to every contract he'd signed for 40 years. He set the paper on the tray table when he finished and didn't say a word for a long time. Stroke recovery back in 1987 was a hard, slow process. There were no computerized imaging machines to tell the therapists exactly what was broken inside his head. There was only Carol, the physical therapist, who showed up every morning at 8 and never accepted the word tired as an excuse. She worked Harlan's left side with the methodical patience of someone who knew that the men who quit early were the ones who stayed weak. Harlan didn't quit because he had a reason to get home that Carol didn't know about yet. He refused to let them cancel a single session. He asked questions about what the exercises were doing and why they mattered for his grip. He did the work at night when Carol wasn't there, performing slow repetitions with his left hand to try and coax life back into fingers that felt like they belonged to a stranger. He wasn't trying to recover just to be healthy. He was trying to recover fast enough to save his life's work. Then the social worker came by. She sat down across from Meredith in the hallway and explained that discharge planning could get complicated without the family working together. She used careful, professional words, but the message was clear enough to see. Dale and Roy had already talked to Harlan's doctor about long-term care and rehab facility options. The social worker called it exploring what's best for his recovery, but Meredith called it something else when she told Harlan about it later that evening. Harlan sat with that news for a long time. His sons had mortgaged his land and divided what was left, and now they were talking to a doctor about keeping him somewhere he couldn't fight back from. Whether that was a real plan or just Dale being Dale didn't matter much. The result was the same. He asked Meredith to find him a phone number for Gerald Mast, an attorney over in Garnavillo. Mast had handled her father's estate back in 1974, and while Harlan didn't know if the man was still practicing, he knew the man was straight. Right now, being straight was the only quality that mattered. Meredith found the number and dialed it herself. She had to hold the phone for him because his right hand was still shaking too much to manage the rotary dial. Gerald Mast picked up the phone on the second ring. He was 61 years old and mostly retired, but he still kept an office above the hardware store in Garnavillo because he didn't quite know what else to do with his Tuesday afternoons. He remembered Harlan from some estate work back in 1974, and he remembered him as a man who asked careful questions and never signed a single paper until he understood every word on it. When the voice on the other end of the line came through slow and halting, struggling over every syllable, Mast didn't try to rush him. He simply pulled a legal pad from his desk drawer, uncapped his pen, and sat back to listen. Harlan talked for 11 minutes straight. Mast didn't interrupt him a single time. When Harlan finally finished, there was a long silence on the line. But it wasn't the pause of a man who was confused. It was the silence of a professional, sorting through everything he'd just heard and putting the facts into the order they needed to be in. Then Mast told him 3 things. First, he explained that the 1981 power of attorney was dead on arrival. A document like that is usually tied to one specific transaction, like a grain bin deal. And once that deal is fully settled, the authority expires. It doesn't just stay open like a checking account for years on end. The paper Dale handed the bank had no more legal power in 1987 than an old receipt for feed corn. And while the loan officer should have caught the mistake, The instrument was void regardless of whether he noticed it or not. Second, the quitclaim deed that divided the remaining 120 acres had been signed without Harlan's knowledge or his consent. That didn't automatically make it a case of fraud, but it did make the whole thing legally unenforceable because Dale had never bothered to get a court-appointed conservator. In the state of Iowa, if you want to manage another person's property because you think they can't do it themselves, you have to go before a judge and submit medical proof. Dale had skipped every bit of that process, and instead of a hearing or a ruling, he'd just picked up a stale document and walked into a bank that was all too happy to let him through the door. Third, and this was the point that mattered most right now, no court had ever declared Harlan Dempsey legally incompetent. He'd suffered a stroke and he was still recovering, which meant his speech was slow, but none of that stripped him of the authority over his own land in the eyes of the law. Dale hadn't stepped into a legal vacuum where there was no owner in charge. He'd stepped into a situation where the owner was simply inconvenienced, and he decided that was close enough to being incapacitated to do whatever he wanted. Mass told Harlan he would file a lis pendens on those 200 mortgaged acres that very same afternoon. Harlan asked what that meant in plain English. So Mast explained that a lis pendens is a formal notice recorded against a property to show there is a legal dispute pending. It doesn't reverse the damage right away, but it freezes the situation so the bank can't sell the note or transfer the interest until a court resolves the claim. It was a way to buy them some much-needed time. He also promised to send a letter to First Savings Bank that day to flag the defective power of attorney and put them on notice. The mortgage had been executed without any proper authority, and the loan officer who stamped that document was about to have a very uncomfortable conversation with his own legal department. Then Mast asked a practical question about the money. Attorney fees weren't cheap, and a fight like this could easily run several $1,000s if Dale decided to hire his own counsel and dig in his heels. He needed to know what assets Harlan had that weren't currently tied up in this mess. Harlan told him about the Oliver 1800. The title was in his name alone, with no liens and no co-signers. It was a tractor the boys had never touched without permission, and it had never been offered as collateral or rolled into the farm's operating debt. It was just a piece of clean, clear iron sitting in the machine shed, with the keys resting on the left rear tire, where he always left them. Mass told him that would cover the costs if it came down to it. The legal path was finally clear, and the mechanism was in place. But Mast still needed evidence of exactly what Dale had told the bank and when he'd said it. That meant it was time to talk to Roy. Roy Dempsey had spent his entire life being the second name on the paperwork. That wasn't out of cruelty, but it was just the way his life had taken shape over the years. Dale was the one who made the phone calls and worked the angles, while Roy was the one who showed up to do the work and signed his name wherever he was told. He'd spent a long time telling himself that this was just how families divided the labor, with one person thinking ahead and the other following through. It wasn't until he was sitting in a hospital parking lot in Elkader with the engine off that he started to wonder which of those roles he'd actually been playing. Harlan called him 3 days after that first talk with Mast. He didn't call Dale, he called Roy. He didn't start with accusations or use the legal language Mast had given him, and he didn't even mention the word fraud. He just asked Roy if he would come sit with him for a little while, and that was all it took. Roy told Dale he was heading to the co-op to pick up some hydraulic fluid, but he drove straight to the hospital instead. He walked into the room alone. Harlan waited until Roy had settled into the chair beside the bed with his coat still on and his hat in his lap. Then he pulled the quitclaim document out of the tray table drawer and set it on the blanket between them. He used his right hand to smooth the paper flat so Roy could see it clearly. Then he asked his question. "Did you read this before you signed it?" Roy looked at the document for a long time before he looked down at his hat. He admitted that Dale had handled all the paperwork, and that was the only answer he had. Dale handled it, Roy signed where he was pointed, and he'd simply trusted that if his brother said it was legal, then it must be legal. He hadn't read the power of attorney or the quitclaim, and he hadn't asked the loan officer a single question. He'd just signed his name in 2 places on the same afternoon and went home to try and forget about it. He was thinking about it now, though. Mast drove up to El Cater the next day with a legal pad and a notary stamp in his bag. Roy sat with him for an hour and gave a signed affidavit, confirming that Dale had told him the 1981 power of attorney was still valid. He admitted that he believed the whole transaction was legal and confirmed that Harlan had never been consulted or even informed about what was happening. When it came time to sign the affidavit, his hands were steadier than they had been when he signed the quitclaim. Roy wasn't entirely innocent because his name was still on both of those documents, and a new affidavit doesn't just erase an old signature. But there is a big difference between the man who draws the map and the man who follows it without looking. And that was a difference that was going to matter once they got in front of a judge. Before Roy left the hospital that afternoon, he noticed the call button clipped to the rail of Harlan's bed. The cord had been fraying where it met the plastic housing for at least a week, and even though a nurse had mentioned it, nobody had bothered to fix it yet. Roy reached into his coat pocket and pulled out a roll of electrical tape, the kind he always carried during the harvest season. He wrapped the splice 3 times until it was tight and clean. Then he pressed it down with his thumb and set it back on the rail. He didn't say a word about it, and neither did Harlan. Some things in this life don't need an explanation. Roy knew how to fix what was right in front of him, even if he hadn't always known what that was until this moment. With Roy's affidavit in the file, Mast finally had the evidence he needed to move forward, but Dale wasn't the kind of man to let go of 80 acres of land without putting up a fight. Dale went out and hired a lawyer from Dubuque named Pratt. This wasn't some local fellow with an office above the hardware store who handled wills and traffic tickets. Pratt was a specialist in farm debt and creditor fights, the kind of man whose entire career grew out of the farm crisis, like weeds taking over a fallow field. He had spent 5 years sitting between families and banks, trying to find a middle ground before a judge had to start swinging a gavel. Dale knew exactly what he was doing when he picked him. He had found a man who could turn a panic move into a legal argument. Pratt sent a letter over to Mast that laid out their side of the story. He argued that the Sons had acted in good faith during a time of total economic collapse, and he didn't pull any punches about the numbers. The $47,000 operating loan was a real debt, and the threat of the bank taking the dirt was just as real. Iowa farmland had been losing value for 5 straight years, and with Harlan unable to speak or lead, the farm was a ship without a captain, right as it hit the rocks. The Sons stepped in because someone had to. The mortgage kept the bank at bay, and the quitclaim deed made sure the family kept what was left. Pratt wanted the court to look at the mess of the 1980s and see the practical necessity of Dale's choices, instead of throwing them out on a technicality. Now, this is where the story gets a little heavy, because Pratt wasn't just making things up to win a case. That operating loan was coming due, and the crisis wasn't just a headline in the paper. It was a ghost that had already moved into half the farmhouses in the county. Dale had watched the same foreclosures Harlan had watched, and while he came to a different conclusion, the fear he felt was genuine. When he walked into that courthouse, he wasn't acting out a script. He was driven by the same bone-deep terror that pushed hundreds of Iowa families into corners they couldn't back out of, making choices that either saved the legacy or buried it, depending on which way the wind blew the next year. Dale wasn't some villain waiting for his father to stumble so he could grab the keys to the kingdom. He was a man who let panic take the wheel, and panic has a way of making a wrong turn look like the only road home. Mast read the response and acknowledged the pressure the family was under, but then he set it aside because good intentions don't create a legal right where none exists. Just because Dale believed the power of attorney was still good didn't make it so, and his fear of the bank didn't give him the authority to take the land for himself. Iowa law has a specific path for these situations involving conservatorships and court hearings, but Dale had decided to jump the fence instead of using the gate. The question for the court wasn't whether Dale had his reasons, but whether those reasons gave him the right to act. In the eyes of the law, they didn't. First Savings Bank was watching this fight from the sidelines with a lot of sweat on their brow. They were holding a mortgage that two lawyers were now arguing might not be worth the paper it was printed on. If a judge ruled that the security interest was invalid, the bank would be left holding a $68,000 debt against a man who never signed for it and had no legal obligation to pay it back. Their legal department sent a quiet letter suggesting that maybe everyone should sit down and settle this before it became a matter of public record in a Clayton County courtroom. By late November, Pratt came back with a settlement offer that tried to split the difference. Dale would keep 80 acres, Roy would keep 40, and Harlan would get the remaining 200 acres back. The catch was that the bank debt would stay attached to Harlan's land, putting his name on a loan he never asked for. It would make the immediate pressure go away and keep the family out of court, letting everyone walk away with a piece of the pie. Mast drove out to Elkader and sat down with Harlan to explain the whole thing. He laid out the terms, the risks of a trial, the mounting costs, and the fact that no one knew for sure how a judge would rule. He didn't tell Harlan what to do. He just put the facts on the table and waited. Harlan read through that settlement, moving his eyes over every single line. Then he turned it face down on his blanket. "No," he said. Mast sat there for a minute with that rejected offer. Then he changed the subject and asked Harlan what it was he wanted to say about that Oliver tractor. It wasn't about what the machine was worth or how to sell it, but rather what was hidden inside it. Harlan told him about the steel toolbox bolted to the left fender, a simple green box with a latch that had never seen a lock. He said that if you looked under a greasy shop rag and a crescent wrench that had been sitting there since 1971, you'd find a manila envelope. Mast asked what was in the envelope, but Harlan wouldn't say. He just told the lawyer to drive out to the farm and see for himself. So Mast took the drive. Inside that envelope, he found the history of a man who took care of his business. There was the original title to the Oliver 1800 from 1969, showing a cash purchase with no liens and Harlan's name as the sole owner. There was a signed receipt from the dealer in Monona proving he'd paid the full price out of his own pocket. He even found a spiral notebook where Harlan had logged every repair and oil change for 24 years, all written in a steady, careful cursive. But there was a fourth item in that envelope, and that was the one Mast took back to his office and placed right in the center of his desk. It was a letter from the Federal Land Bank dated March of 1983, a year when the bank was scouring the countryside trying to buy up distressed farms before the bottom fell out. The letter was a formal offer to buy Harlan's 320 acres at the current market price, which was already low enough to make a man sick. It was a professional, cold-hearted offer with a line at the bottom for a response. Harlan had written his answer on that line in blue ink, signed his name, and sent the original back. The paper in the toolbox was the copy he'd kept. It only said 2 words: not interested. That was March of 1983, 4 full years before the stroke ever happened. It was 4 years before Dale walked into the courthouse with an old document and told himself his father wasn't capable of making his own decisions anymore. That one piece of paper ended Pratt's entire argument. The whole extraordinary circumstances defense relied on the idea that Harlan's condition had left the farm without a competent mind to run it during the crisis. Mast's counter-argument was now a hammer, a man who could look at a buyout offer in the darkest years of the farm crisis, understand exactly what it meant, and write back a firm no, was a man who knew exactly what he was doing. He knew the value of his dirt. He felt the weight of the debt, and he made a deliberate choice to stand his ground. Back in 1981, Harlan had signed a power of attorney for a specific reason, but Dale had used it in 1987 to claim power over a man who was still making sharp financial moves years after that paper should have been filed away. The Oliver wasn't just a piece of equipment Harlan wanted to sell to pay his legal bills. It was the safe where he kept his proof. The one thing on the farm he never let anyone else touch was the very thing that held the most important document he owned. When the case finally went before a Clayton County judge in February of 1988, it didn't take very long at all. The Clayton County Courthouse in February is a cold, quiet place where the wind seems to whistle through the stone walls. The judge who heard the case was a practical man, the kind of person who wasn't given to long speeches from the bench or fancy legal theories. He spent his time reading the briefs and reviewing the power of attorney, and then he looked for the conservatorship records that simply didn't exist. He sat there and considered the affidavit Roy had signed and the letter Harlan had mailed back to the Federal Land Bank in 1983. Weighing the paper trail against the stories he'd been told. When he finally spoke, he voided the quitclaim deed. The problem was that no legal authority had ever been established to take the land from Harlan, and no court had ever ruled on whether the man was competent to make his own choices. That power of attorney Dale used was tied to a specific transaction that had closed 6 years before he handed it to a bank loan officer, and a transaction-specific document doesn't just float forward in time looking for new purposes. The judge's language was plain and direct, stating that, without a conservatorship or a durable power of attorney Harlan had actually signed for this purpose, Dale had no authority to divide property he didn't own. The deed was void, and the land went back to the man who had spent his life working it. The mortgage was a different matter entirely, but the final outcome for the family ended up being exactly the same. First Savings Bank had accepted a legal instrument that any reasonable review would have flagged as defective, so the court ruled the mortgage was unenforceable against Harlan. This meant the bank's claim had to follow Dale personally rather than staying attached to the dirt. Dale had spent $47,000 of borrowed money to retire one debt and pocketed the rest, but now he found himself owning the whole obligation without the land to back it up. He had gone into that courthouse trying to save the farm from a creditor, and he walked out of the courtroom as that creditor's new target. He didn't put up a fight after that because there wasn't much left to fight with. By April, he'd rented a small place in Waterloo and taken a job with an equipment dealer on the edge of the city. He and Harlan didn't speak again for several years, and when they finally did find their way back to a conversation, it wasn't about the land or the money. Roy stayed right where he was. Harlan offered his son a lease on 80 acres that was formal, written, and witnessed by Gerald Mast before being filed with the county. Every single term was spelled out in black and white, and Roy made sure to read every word before he put his name on the line. That part mattered deeply to both of them, even though neither man was the type to say so directly. When the legal bill from Mast came to $4,200, Harlan didn't flinch because he had known this day was coming. He had already made a call to a collector in Monona who'd been asking about the Oliver 1,800 for 2 years, and they settled on a price of $3,800. The collector drove out with a trailer on a Thursday morning in March, and Harlan stood in the machine shed doorway and watched him load the tractor. He'd pulled the manila envelope from the toolbox the week before, knowing the tractor was just a machine now, and he used $3,800 of that money for Mast, while the remaining $400 came from the savings account where he kept his grain check money. That spring, he went out and bought a used 1971 Oliver 1855 from a farmer who was retiring outside of McGregor. It was older than the 1800 and cheaper by a fair margin, and it carried its own set of stubborn opinions about starting up on a cold morning. He paid cash for the machine and put the title in his name alone, signing the registration the same way before setting the paperwork in the fireproof box under the bed. It sat right next to the deed and the court order he'd had Mast certify before the ink was even fully dry. Dale had acted out of panic rather than malice, and you could say the farm crisis had broken the judgment of better men than him. Panic has a way of making an illegal thing feel like a necessary one when the walls are closing in. But here is the thing. Panic doesn't transfer a deed, and fear of losing something doesn't give you the right to take it from someone else. Harlan understood this without having to say it out loud, which was why he never pushed for criminal charges against his own blood. The land was back where it belonged, and even though the cost was one tractor and a broken relationship with his older son, he decided that was as much as he was willing to spend. By May of 1988, he was back in the field with the sun on his neck. His left hand was still weak from the stroke, but his right hand was strong enough to steer. The deed went back in the fireproof box with the court order clipped right behind it. What his sons never quite understood is that the land wasn't just a financial asset to be managed or traded away when things got hard. It was the thing everything else was supposed to protect, the foundation that held the rest of their lives together. If you're the one holding the deed to your own life, subscribe to see the underdog win through character and old iron, and don't let anyone convince you that a crisis is a reason to hand it over. There is something worth pausing on before we get to the courtroom, because the story of what Dale did is incomplete without the story of what the farm crisis actually felt like from the inside. By the fall of 1987, the worst of the price collapse was technically over, and land values had finally stopped their long slide toward the bottom. Commodity prices had stabilized enough that people were starting to use the word recovery in agricultural papers and extension office newsletters. But recovery is a word for people looking back. For the men still in the thick of it, September of 1987 felt exactly like September of 1984, which had felt exactly like September of 1982. The fear doesn't lift on the same schedule the market does. Dale had spent 6 years watching neighbors he'd known his whole life lose ground they'd farmed for generations. And he'd watched the federal land bank send men in clean trucks to put notices on fence posts. He had been to enough farm sales to know exactly what a man's life looks like when it's laid out on a flatbed for buyers to walk through with clipboards. The $47,000 operating loan wasn't an abstraction to him. It was the number that had been sitting in the back of Dale's mind since spring, getting heavier every time corn prices printed lower than expected. He and Roy were co-signers on that debt, which meant if the farm went, they went with it. That was the math he was running when he stood at the foot of his father's hospital bed and looked at the left side of Harlan's face hanging slack against the pillow. He wasn't calculating opportunity or looking for a way to get ahead. He was calculating how much time he had before November arrived and the bank started making calls. That doesn't excuse what he did, but it explains why a man who wasn't fundamentally dishonest walked into a courthouse and picked up a document he had no business using. Desperation has a way of making the available thing look like the right thing. The power of attorney was there, the bank was willing to talk, and Dale moved. What he didn't account for was Meredith. Harlan's wife had been mostly quiet through the hospital stay, sitting beside the bed and talking to nurses while she drove back and forth between Elkader and the farm with whatever Harlan asked for. She wasn't the kind of woman who announced herself in a room, but she was the kind who noticed things. She noticed the day Dale came in and spoke to the doctor without asking her first. And she noticed when the social worker appeared in the hallway with brochures for extended care facilities. She even noticed the quitclaim deed in the glove box when she borrowed Dale's truck. And she didn't put it back where she found it. Meredith had known Gerald Mast since 1974, back when he'd sat with her and her sisters after their father died, and walked them through the estate with the patience of a man who understood that grief and paperwork don't mix well. She trusted him the way you trust someone who showed up when it mattered and didn't pad the bill. When she dialed his number from the hospital room, she wasn't doing it out of strategy or spite. She was doing it because her husband had asked, and because she'd been watching what was happening long enough to know that someone competent needed to be watching with her. The 11 minutes Harlan spent on the phone with Mast were slow, halting, and expensive in the way that physical effort is expensive for a man still fighting the effects of a stroke. Every word cost him something. But here is what those 11 minutes actually were. They were the moment the farm stopped moving in the wrong direction. It wasn't because Mast had magic or some secret legal trick, but because until that call, there was no force working against what Dale had set in motion. The lis pendens Mast filed that afternoon was a legal instrument, but its practical effect was simpler than its name. It was a hand on the wheel. Roy's visit to the hospital deserves more than a paragraph, too, because what happened in that room wasn't just a legal transaction. Roy hadn't slept well since the day Dale brought the paperwork home. He'd signed it because Dale handed it to him, and because the farm crisis had trained him to believe that slow decisions in fast emergencies were the ones that cost you everything. But he'd driven past the hospital twice in the weeks after Harlan went in, and didn't stop. That's the detail that tells you something about his heart. He knew what he'd done wasn't right, and he just hadn't figured out yet what to do with that knowledge. When Harlan called and asked him to come sit, the word that moved Roy wasn't come. It was sit. Not to explain himself, and not to negotiate a deal. He just needed to be in the room with his father, the way you'd sit with someone you'd wronged when you've finally run out of reasons not to. He sat. The quitclaim went between them on the blanket, and Harlan asked one question that Roy answered honestly, which was the first honest thing Roy had managed in about 6 weeks. And then, because Roy was the kind of man who fixed what was in front of him when he finally saw it clearly, he wrapped that fraying call button with the tape from his coat pocket and pressed it down tight and left without making a speech about it. That's not a small moment. That's a man showing you who he is underneath the panic. Harlan saw it, and he filed it away the same way he filed everything, quietly, for later. The February courtroom in Clayton County wasn't dramatic. There was no gallery full of neighbors, no newspaper reporters, and no long speeches about the meaning of family land. There were just 2 attorneys, a judge, a stack of documents, and a 1983 letter that had spent 4 years in a toolbox under a shop rag. Pratt had built a case out of real economic pressure and genuine fear, and it was a reasonable case for a different set of facts. But the facts he had weren't different. They were specific, and they were documented, and the man who'd written "not interested" to the Federal Land Bank in blue ink was sitting in the courtroom with his left hand folded in his lap and his right hand steady enough now to hold a pen. The judge didn't need long to look things over. The record didn't require interpretation. It just required reading. One more thing about that, Oliver. When the collector from Monona loaded it onto the trailer that Thursday morning in March, Harlan watched from the machine shed doorway, the way you watch something leave that you've already made peace with losing. The tractor had earned its keep twice over, once in the field for 18 years, and once as the place Harlan had kept the only proof that mattered. He'd known, without knowing he knew it, that the toolbox was the right place for that envelope. It didn't belong in the fireproof box or the filing cabinet. It belonged in the thing he never let anyone touch without asking. The 1855 he bought that spring from the man outside McGregor was older and louder and had a clutch that required a firm opinion. Harlan titled it the same afternoon he drove it home. He didn't need a power of attorney to know where he stood. He just needed a machine that worked and a family that finally understood the value of a man's word. Subscribe to see the underdog win through character and old iron.